My name is Rebecca McCarthy and I'm Associate Solicitor in the Lifetime Planning team. A power of attorney is a legal document that allows you to appoint people you trust to act on your behalf. The person making the power of attorney is known as the donor, and the people they appoint are known as their attorneys. There are 4 types of powers of attorney. A general power of attorney is a document which can be used immediately and does not need to be registered, but will cease if someone loses mental capacity, and they are usually limited to last for only a short period of time. These can be helpful for short-term use, for example if you want someone to be able to sign for you whilst you're out of the country. An enduring power of attorney, or EPA, was a document that could be made up to October 2007. You can no longer create these, but if you made a valid EPA before October 2007, it will still be valid now. An EPA allows people to help you manage your finances and buy and sell property. Unless restricted, these can be used before a person loses mental capacity, but only with their consent, and also if the person loses mental capacity in the future. EPAs must be registered when the donor starts to lose mental capacity, but must not be registered before this. A Property and Finance Lasting Power of Attorney, or Property and Finance LPA, is the document that replaced EPAs. It allows people to help you manage your finances and buy and sell property. A Property and Finance LPA must be registered before it can be used. Unless restricted, a Property and Finance LPA can be used straight away whilst a person has mental capacity, but again only with their consent. And the Property and Finance LPA can continue to be used if the person loses capacity in the future. A Health and Welfare Lasting Power of Attorney, or Health and Welfare LPA, allows people to help you make health and welfare decisions if you lose mental capacity. These can be day-to-day decisions, such as your diet, who is allowed to visit you, or can be bigger decisions, such as whether you should continue to live in your own home, or significant healthcare decisions. You can also choose whether to give your health and welfare attorneys the authority to give or refuse consent to life-sustaining treatment. Health and welfare LPAs must be registered before they can be used, and they can only be used if the donor lacks mental capacity. Whilst you are able to make your own healthcare decisions, it's important that you are the only one to do that. An attorney should be someone who you trust to act in your best interests. Often these might be family members or friends. Some people choose to appoint professional attorneys, but there is no requirement to. You can appoint primary attorneys and replacement attorneys. Replacement attorneys' powers are only activated when something happens so that the primary attorneys are permanently unable to act. So it's important to think about when and how you want your attorneys to be able to act. It's often advisable to have more than one attorney appointed initially in case something happens and one of your primary attorneys is temporarily unavailable. It's important that any attorneys who will act together are able to get along. Start with an initial meeting with one of our friendly team members. We'll discuss your circumstances, who would be best for you to appoint and how to appoint them. We'll also discuss any recommended instructions or guidance to include within your documents and which types of powers of attorney are best for you. The documents are then prepared, and after you've had a chance to review these, you come in to sign them. A person known as a certificate provider must sign any lasting powers of attorney to confirm that you understand what you're doing and that no one is forcing you to make the LPA. In most circumstances, we can act as your certificate provider. We then circulate the relevant sections of your LPAs to your chosen attorneys for them to sign. Once everyone has signed, we arrange the registration of your LPAs on your behalf. The registration process can vary depending on the Office of the Public Guardian's workload at the time. Their present timescales are estimated at 8 to 10 weeks, but these have been in excess of 20 weeks previously, which is why we recommend registering LPAs as soon as possible to avoid delays in being able to use them. There is proposed legislation which would mean that only the donor can register an LPA in the future, not the attorneys. And whilst this is not yet in force, this again creates another reason why an LPA should be registered straight away to avoid issues in the future. incapacity and you do not have a valid, enduring or lasting power of attorney, then no one will have authority to make decisions on your behalf or access your finances. Your family would need to apply to the Court of Protection for a deputyship, which is a time-consuming and costly process. Whilst the Court of Protection can grant a personal welfare deputyship, these are very rare and only granted in exceptional circumstances. Most people would not be eligible for a personal welfare deputyship, and the majority of health and welfare decisions would therefore be made by the people responsible for the care, so often doctors or care providers, based on what they deem to be in the person's best interests. I hope you found this short video helpful. We regularly advise clients who want to make or review powers of attorney, as well as attorneys who want advice on what to consider when they start acting. If you have any queries, then please do not hesitate to get in touch. The contact details for myself and the Lifetime Planning team are on the Ashtons Legal website.